Hello, everyone, and thank you for joining us for the webinar today. We're going to be talking about wills versus trusts. I am Carol Anderson. I am the marketing director here at Generations Law Group. So a little bit about Generations Law Group. We are an elder law firm celebrating 15 years in business. We specialize in estate planning, probate, guardianships, conservatorships, mass health planning and applications, and asset protection. We have 3 offices in Acton, Burlington, and Sudbury, Mass. And our team is dedicated to providing quality service with a friendly touch that maintains relationships with our clients long after documents are signed. So today our presenter is Phil Summers. Along with his wife and partner, Kathleen, Phil has founded Generations Law Group. He's our managing partner and has provided assistance to a variety of clients and their families over the years. Phil came to the field of elder law and estate planning through his own family experiences in caring and planning for close family members. He concentrates his legal practice in the areas of estate planning, probate, and guardianship. Phil is our probate team's leader, where he experiences a variety of issues with wills and trusts on a daily basis. So Phil, I'm going to let you take it over and teach us about some wills and trusts.
Okay, great. Carol, thank you very much. Can everyone see my slide okay? Hopefully that will
Yes.
see it. Okay, great. Hi, my name is Phil Summers. I'm an attorney with the Generations Law Group, and thank you for attending our program today on this rainy, dreary day. What I'll be talking about today is wills versus trust. And when we talk about wills versus trust, it's really what is the cornerstone of your plan? Which is better for you and your family? Is it a will-based or a trust-based, or is it some combination? Remember, there are many factors that go into making this decision as to which is better. It all depends on your circumstances. As when they ask an attorney, they always give them some facts, and they say, "Well, what's your opinion?" Well, it depends. It depends on you, your family, what's important to you, your priorities in life. So let's do something real quick first. It's a little bit humorous. It's a quick clip from an ABC show, but I wanted to just kind of give you an idea what happens when you don't plan, when you don't have an estate plan or a will or a trust, the problems it can cause. So I'm going to hit the play button and hopefully everyone will be able to hear it.
Unfortunately, we have longevity on both sides.
But what if, you guys? What if? You have to make another will. Without a will, there'll be nothing but fighting and accusations, and eventually the 3 of us will stop speaking to each other, and years will go by, and our children won't even know their cousins, and we'll spend holidays apart. I'll be with my husband and children, and Axel will be across town with his family, each wondering if the other is having a Merry Christmas, but each too proud to pick up the phone. And Brick, who refuses to choose sides, will be eating Christmas dinner all by himself at a Perkins restaurant, being served by a waitress who feels sorry for him. You have to make a will. A specific detailed who gets what, or it'll tear us apart. I've seen it before. Look at Casey Kasem's family.
Wait, why am I the one being pitied by a waitress?
So I think you get the idea.
Unfortunately, we have
of what happens when you don't plan. It's fail to plan to fail. It's kind of the words of an estate planner. So let's talk about some key definitions about wills and trusts, but also some of the things that we want to consider as we discuss this. First of all, probate. I think we all know that this is the legal proceedings that when you pass away, when you die, the probate court gets involved. And it's really to take your assets that are held individually in your name and to transfer those to hopefully your beneficiaries or your heirs. Probate also includes guardianship and conservatorships. So if you're incompetent or you're in a coma or something of that nature, and someone needs to get authority to make decisions for you. If it's healthcare, it's a guardianship. If it's financial, it's called a conservatorship. If you need to convey a house for your care, you'll need to have someone have the authority. So if you don't have the estate plan documents in place, unfortunately, your family or loved ones may have to go to court to get that authority for you. Also, there's taxes. It's not something we always like to talk about, but there's many different types of taxes. There's estate taxes, gift taxes, income taxes. For the purposes of this presentation, we're going to be talking about estate taxes. And again, I'm going to keep it at a very high level. I'm not going to get into the nitty gritty, but just to kind of give you an idea, in Massachusetts, we're what's known as a threshold state. That means anything over $1 million, which is a threshold, then the full million is taxed. But one of the things you have to consider is what is in your estate. So and there's two types of estates you can really look at. First is one is your probate estate and one is your taxable estate. Your taxable estate is everything. It's your money, your investment, your savings, life insurance, if there's any death benefit, that's considered part of your taxable estate. Real estate, it's all totaled up into, and also your personal property, the things you have. That's all totaled up as of your date of death to establish your basis for your estate tax. Your probate estate is different. These are the only things that have to go through probate. For example, anything that's only in your name. If you have a checking account and it's in your name only, it'll have to go through probate. If the account has a joint owner, or if there's a POD, payable on death, to somebody else, or a beneficiary, like a life insurance policy, these are the things that do not go through probate. They avoid probate. Real estate, if it's jointly held, for example, with your spouse, upon your passing, it's automatically conveyed to your spouse. If it's held with somebody else, if, for example, in tenants in common, it would be, if there's rights of survivorship, it would go to that person upon your passing. Remember, probate is only those assets that are in your name. The one thing about probate, I should just take a little sidebar here. If anyone's had a loved one or family member who's gone through it, it is really a excruciatingly slow, annoying process. In Massachusetts, you need to keep a probate case open for 1 year to allow creditors to file a claim. Probate's very expensive. So just as a rule of thumb, figure 5% of the total estate of value could be used up in the filing fees, legal fees, accountants, just to probate an estate. And also the last thing that's the downside about probate, it's a very public process. So if you wanted to go in any of the county probate courts, you could look up and see what your neighbor received. A lot of creditors do that, as a matter of fact. If their adult children have credit problems or they have judgments against them, they will swoop in and grab the inheritance. So something to consider about probate. So let's talk a little bit about estate planning, kind of in general. What is most important about your estate plan is should reflect your values. For example, supporting a surviving spouse, fund education for your kids, your grandkids. Maybe it's charitable giving, but it really kind of reflects what's important to you. Reasons for estate planning, maintaining family harmony. Just a quick story. I had a client once. His parents had a long-term marriage, roughly 40 years. Unfortunately, his mother passed and the father remarried in his mid-70s. And the subsequent wife and his father created their own estate plan. All the prior children still being remembered in the estate plan. Once my friend's father passed away, his second wife changed the estate plan, the will completely, and completely cut out her stepchildren. So these are one of the things I'm talking about, wills that have a problem, an issue. It may not always go your inheritance to where you want it to go, where you intend it. It doesn't consider some other factors that may affect the distribution. So other reasons for planning, legacy planning, to impart your values, what's important to you. Asset protection, if you're concerned about nursing home and nursing home costs. In this area, between $15,000 and $17,000 per month on average for nursing home care, that will wipe out most families' hard-earned income. And also estate tax planning to minimize estate planning, the use of trust. I'll talk more about that in a moment, but just trying to give you some broad-based goals. Your estate plan reflects what's important to you. Some other goals. So talking generally about estate planning, a well-crafted estate planning will address some of these goals here and maybe others. And estate plan is not only after you pass away, but also for while you're alive or for your quality of life and for you and your loved ones. So the first one, I call it the W's. Give what I have to whom I want, the way I want, when I want. It's a little bit of a mouthful, but in essence, what I got and who I want to give it to. So that's part of the estate planning process. Also for the care of you during your lifetime. If you become incapacitated, the estate planning should kind of cover those facets to make sure you're getting the care you want and there's money there. And you make sure you know what you want done, or the care for others, maybe a surviving spouse, maybe for a minor child. Minimize or limit probate. So that's a big issue. We've talked a little bit about that, but probate can really delay your loved ones from getting an inheritance. So if it's a will-based plan, in order to get it probated, all the creditors to make a claim, it could be a year, 16 months. And just to let you know, the probate courts today are way behind with COVID. COVID has impacted the probate courts. They're working at half staff. They're working, many are working remotely. And what would usually take 4 to 6 weeks to get someone named as what's called a personal representative is now taking oftentimes 3 to 4 months. So it's typically doubling the time. So if your family is in need of the assets from your estate, it could be a problem if you have to go through probate. Other goals, charitable planning, charitable intentions. If you have a favorite charity that you want to show your support, your estate plan can be used for that purpose. Pass on the values and ideas to your children. That's one of the important things that often overlooked in estate plan. We think it's just give something from one person to another, but no, maybe you have it used for specific purposes. Buying a house, helping a child out, education we talked about, maybe helping some other loved one. An estate plan can do that. It passes on your values, in a way. And the last thing is really it can maximize the assets distributed to your loved ones. And that's part of the process is minimizing your estate tax. We'll talk a little bit again about estate taxes, but by using certain trusts, we can catch the maximum estate tax. For example, when the couple, for the first to die, have attributed to the first to die, and then when the second to die, of the spouse of the couple, then the overall estate tax is reduced. It basis for the estate tax, but let me get into that in a moment. I don't want to confuse the issue at this point. Let's talk about wills. I'm sure we're all familiar with a bit. In a will-based plan, the will provides us with the instruction sheet as to how you want your estate distributed after your death. It takes effect on your passing. It tells us again who gets what, it tells us who will be managing the estate. It's called a personal representative now in Massachusetts. Used to be called an executor or executrix, but in the will, it'll detail who that person will be, and also maybe a successor PR or a co-PR, but I would not recommend that. Also, if you have minor children, it'll designate who will be the guardian. Wills can be simple. I give everything to my spouse, and then if she is not at the alive at my passing, then to my children, or something like that. Or you can make complex, leaving specific items to certain people, charities. You can hold money in an estate for an extended period of time for the benefit of a child. Maybe a child is a minor. Wills are fairly low cost as compared to a trust, but there's certainly some downsides to a will. Wills can be changed as long as you are competent to do so. So that's also a plus and minus. But certainly with a will, things you need to consider is that, again, it only takes effect on your passing, but it also delays the inheritance. If you die without a will, that causes even more problems. You die what's called intestate. You did not have a will. That's what intestate means. Your property will be distributed according to the laws of the Commonwealth of Massachusetts. Quick story, had a client a number of years ago. It was a husband and wife, they're a young family. The husband's estranged father had abandoned the family 20 years prior. The father had absolutely no contact with his father. When they never had a will created, so when he passed, everyone assumes my spouse gets everything. That's not necessarily true in Massachusetts with the intestate distribution laws. So unfortunately, the estranged father got a portion of the estate. It was a small portion, but he did collect something from the estate, which he took. And unfortunately, the widow still had her, still had to kind of continue on with a diminished estate. So some things to think about, you need at least have a will in place to make sure it's not the laws of the Commonwealth. Wills do not provide for incapacity issues. Only takes effect when you die. Doesn't help to control assets while the person is still alive. Or if they become incapacitated or incompetent, who's going to control the assets? That's again, you have to go back to the probate court to get a guardianship to control the for healthcare decision or a conservatorship. But again, the will doesn't handle that aspect of your life. Wills have to be probated. Trusts are a private agreement and stay out of the probate court. Also, it could be problematic if crossing state lines. Like for example, if you own property in multiple states, you're a resident of Massachusetts, so we probate here. But if you have a property in Florida or up north, then you have to do another probate, what's known as an ancillary probate in these other states to manage the property. Wills also do not control all of your property. Sometimes it's outside assets are moved outside of your estate. We talked about earlier, jointly held accounts, life insurance, retirement plans. They are typically have named beneficiaries or jointly held. Those do not go through probate, so those are not controlled by your will. Wills provide direction and protection for a short time, not for the lives of the surviving spouse, children, and grandchildren. Let me give you an example. We had an older client in her late 70s. Her sister had passed away. And the sister had created the will 25 years earlier, had not updated it. So when she passed, her sister received a large inheritance. But here's the issue. She was in a nursing home. The money went right to the state because the state was paying for nursing home care. Had she updated her will to reflect kind of the current issues at the time, it could have been structured where a trust was set up, the money put in the trust, and the money could be used for her quality of life, for things that were not covered by Mass Health. So a little bit of planning ahead would have benefited her sister greatly. Unfortunately, the money did not go where it was intended to go. And then finally, I want to mention about an issue with the wills is more susceptible to challenges because probate is an open process. It's open to the public. It's very easy to object. You can object to the allowance of the will. You can object to the naming of the PR, objecting to the accounting. Had another client, unfortunately, the sister who was mostly cut out of the will when it was probated. She objected because she didn't get the toaster in the will. And so every step of the way, she filed one frivolous motion after another, delay, costs ensued. It was unfortunately a intolerable situation that just caused hard feelings among the siblings and the intended heirs. So remember, wills are subject or can be subject to litigation if not properly handled. Okay, Let's talk a little about trust. We talked about wills, but let's move on to talk a little about trust. So a trust, at a high level is an instruction sheet of what you want done after you die, and also should you become incompetent or incapacitated. It's a private document between you, your trustees, and the beneficiaries. Remember, if you create the trust, you're the grantor or the trust maker. You name a trustee. It could be yourself in case of revocable trust. But also you have some named beneficiaries. You could be a beneficiary of the trust too, but the trust owns the asset, is titled in the trust name. Um, in a trust, you want to choose a plan that will take care of you during your lifetime. So again, wills are when you pass away. Trusts are contemplate should you become incapacitated. It thinks that ahead. You're putting in the instruction sheet of what you want done, how you want to live, the quality of life. So these are the things that you can put in your trust to alert your successor trustee. These are things how you want handled. You keep control. It's really a big thing about trust. You're keeping control of your assets while you're still alive. And also when you pass on, the trust can continue on after you pass. And in a trust, you want to outline what you want to have done in the event of disability. You talked about how you want to be taken care of, where you want to be, and who will be making these decisions. Just as a side note, these are conversations you should really have with your trustee or your power of attorney or healthcare proxy in advance. It's not something you'd want them to guess later on as to how things you want to have handled, but these are important conversations. We have an ebook on starting that conversation, how to have those conversations, and certainly Carol can provide that upon request. Just to continue, descendants, you serve to trust, you can certainly control the distribution. Typically, in a will or if you die intestate, the distribution is made immediately. In a will, you can make some provisions, but in a trust, you can certainly control when the distributions were made. So, for example, if you have an adult child, maybe you give that person half the estate of your estate or their inheritance when they turn 25. Maybe the other half at 30 or some other suitable age. It all depends upon your children. But maybe you carve out certain exceptions or stages for health, if the expenses to be reimbursed by the trust, or for education, going to school. Maybe they're going for an advanced degree. There could be a purpose that you would have the trustee permit to be taken out of the trust. Maintenance for expenses, you need a car or rent, and also support. We call it HEMS, HEMS. That's when they do it. One way to put these kind of exceptions in a trust, but it gives you some control instead of having the child get all the money at once. I affectionately call it the Harley money, because if you get it all at once, the son or daughter may go out and buy a Harley Davidson, and that maybe not be the best use of their inheritance or what you had intended. You can also have what's called a lifetime beneficiary controlled trust. And this really depends on how you, I guess, your viewpoint of your child. Maybe your child is doing great and you have someone else manage this trust. Maybe they don't need it. And if they do need it, it's there, but you have a trustee kind of controlling the purse strings. Maybe the intention is, unless your children need it, maybe it goes to the grandchildren. Or maybe you're concerned about your child's spendthrift habits. Maybe they have an addiction or substance abuse problem. And maybe you want to put some controls in there just to make sure the trust funds are used for a purpose that you think is appropriate. Also, a trust can be used as and there's different types of trust, but as a protection mechanism. Maybe you don't want half your son's inheritance to go to your ex-daughter-in-law or ex-son-in-law. So we can certainly use trust to do that. In a will, it's a public process. So any ex-daughter-in-law and son-in-law wouldn't know what your child got. So trust is a way we can do that. So really can protect beneficiaries from himself or herself, creditors, predators, and divorce, as we like to say. There's really two major types of trust. There's revocable trust and there's irrevocable. Let me talk about a revocable trust first. This is where the grantor, the trustee, creates the trust. Great way to avoid probate on all the downsides and negativeness of probate. It's also an excellent estate tax planning tool. So let's go for that back to that couple that we talked about earlier. Maybe they have $3 million in total assets. So you remember, in a total estate, you're including the house, life insurance, all financial products, personal property. When you total it all up, maybe you get to $3 million. I'm just making up a number. Now, with a revocable trust, and particularly if you have a couple here, you can carve out that when the first dies, half is attributed to up to the estate tax maximum of $1 million. And then when the second to die, now remember, we've carved out first and tribute to the first to die. When the second to die, and that's when the estate tax really comes into play. You don't pay on the first to die in a couple situation, but in the second to die, the total estate tax basis has been reduced by $1 million. Remember, we've carved out $1 million attributed to the first to die. The second to die, now that person's total estate is only $2 million. So the estate tax goes down considerably. Just to give you some rough numbers, some estate tax is between 5 and 16% in Massachusetts. We find you typically fall around most estates that we see in this area around the 10% estate tax obligation. So something to consider. Wills don't do that, because you get all the money all at once. The estate tax is considered at the day with a will. Trust, again, is an estate tax mechanism to minimize the estate taxes and preserve the inheritance or distributions to the attendant heirs. A revocable trust is easy to amend. The person who creates a trust, they can amend it during their life. It becomes irrevocable after they die, but it's easy to amend. During the trust maker's lifetime, they maintain control over the trust and the property. They can take stuff in and out. So our little drawing here, this little safe, you could open up the door and put stuff in. You could take stuff out, change the terms, because it's fully amendable. The downside, the chief downside of revocable trust, there's no protection from Mass Health, because if you can get at it, so can Mass Health. So it would be no asset protection, so to speak. The second major category, again, there's so many different types of trust, is an irrevocable trust. This is also similar to revocable, a great way to avoid probate. It's a private agreement, stays out of the courts. You can remove the money. Here's one of the chief benefits in terms of asset protection. You can take money out from a taxable estate. So in this example here, you take money out, you put it into the steel box. It's protected. It's protected from creditors. It's protected from ex-daughter-in-laws and ex-son-in-laws and a whole bunch of other people. But it's also protected from you. You can't get at it. You can't be the trustee. Someone else is controlling it. Big downside, but it can be drafted in a way that can protect a property for Mass Health, a Mass Health lien. Great planning tool. Maybe not appropriate for everyone. Again, it depends. We talked about that earlier. The situation depends on your circumstances. Life insurance is a product that can be put into an ILIT. It's called an ILIT, irrevocable life insurance trust, to take it out of your estate. Remember, you're reducing the taxable estate. All benefits downstream in terms of what's left over to distribute to your loved ones. Downside is the loss of control. Again, it's that steel box. And plus, in Massachusetts, you need to get through that 5-year look back. There's unlimited transfer among spouses, but there's still, in order to truly take that asset out of your estate, there's a 5-year look back. With a trust, you can create provisions for you and your spouse or your significant other upon your passing. You can certainly create provisions for minor children. Again, it's called a living trust by our life, and there's a reason for it. You put these provisions in. You can create values, your values in terms of a trust of what's important to you. We talked about charitable giving. but also you can plan for pets. We can have what's known as a pet trust in Massachusetts. In the state, we can't give a bequest to a pet. It has to be put into trust. This is the Leona Helmsley rule. You probably followed this case quite a few years ago, where she gave the bulk of her estate to, I think, is her beloved dogs at the expense of her children. So in Massachusetts, you can't do that, but you can put it in trust. And someone would be the trustee, would manage the trust for the benefit of the pet. Upon your pet's passing, it could be used for some other purpose, but we can do that in Massachusetts. Firearms, you have a gun trust. The firearms, there needs to be a specific language for the transfer of firearms. We can also save money in the long term. Now, trust typically costs more upfront, and there's more thought, not more thought, but it's more complex upfront, thinking through all the scenarios of what's important to you. But in the long run, it really saves money because you're avoiding probate. Again, probate can be very expensive, so this is certainly a tool to save. If you look at from a probate expense, time expense. Remember, trust assets are available immediately upon your passing, or based on other terms if you want to continue on. And finally, it saves income taxes, or excuse me, estate taxes. But certainly using deductions and some of the other mechanisms, reducing the estate tax base. So really some benefits there. How can we decide which is better for us? These are questions you should consider together, or each person's situation is different. Does your current plan provide for your heirs and beneficiaries with asset protection against creditors, divorce, lawsuits? Maybe this is not important to you. Maybe you're not concerned about nursing home costs, trying to have asset protection. Maybe you have long-term care insurance that will help, pick up the burden should you need nursing home care. The delay in probate can be an issue. If your family desperately needs your inheritance or access to your financial products or money, probate could delay it. It could delay it for a year, 2 years, or at least 16 months. Very, very difficult. First marriages, blended families, that can be an issue, as I mentioned earlier, of the, when the couple had long-term marriage and the wife passed away, father remarried, and then unfortunately the assets from the married couple did not go to the children, was what they wanted. So trust may be a better choice there. Family disputes, boy, I think attorneys would be out of business if it wasn't for family disputes. And probate wills are certainly a rich source of disputes. You would not believe how people can argue. It seems people argue more over money and things of that nature more than anything else. And, probate courts are often used to kind of settle old scores or past slights. And because it's an open process, it's rich for mischief, so to speak, to kind of get at your siblings or, some other family member. So unfortunately, the probate court does cause that problem. Some people feel their family gets along fine, and a probate court would not be an issue. So, but again, an important question to ask. Also, if you become disabled, are you certain your healthcare or financial wishes will be honored or followed? A will doesn't have that in there. Trust and other documents would have those protections in place. And then finally, you should really have your trust or will periodically reviewed. We'd like to see it every couple of years because things change in your life. Maybe your financial situation has changed. Maybe what's important to you has changed. Maybe, you want to change the balance of the inheritance. Maybe instead of having everything going equally to your children, maybe you want to take care of them some differently. Maybe one is taking care of you, or maybe another child is doing exceptionally well and doesn't need the money. So these are things that you may want to periodically look at, as well as the probate laws. They've changed in Massachusetts. 6-7 years ago, we had a major revision of the probate laws, which really impacted a lot of estate plans. So the judge's scorecard is kind of a little, way to kind of sum up the advantage and disadvantages. And we've talked to many about that, but there's also what I call a hybrid approach. You could have a living trust-centered or cornerstone plan, but also have a will that catches anything in case you didn't put those things into the trust. You didn't put that bucket called the trust. So maybe you have an outlying bank account. A will will capture it, and you can have the will feed it into your trust to make sure it's, again, managed by the terms of the trust. Or you can have a will-centric approach to your will, but maybe you carve out certain assets that you want to go to for a specific purpose or person. Maybe it's a child that's a special needs, and you want to have a special needs trust set up to make sure their care is taken care of going in the future, to think that through. Again, there's some of the downsides of the will: no asset protection, cost of administration is a lot higher, and it's not, it doesn't handle things during incapacitation. And then, just as a concluding slide, having the will or trust based on what was best for you and your family is certainly important, but don't forget these other things. Durable power of attorney. If you become incapacitated, you need someone to step into your shoes to make financial decisions. If you run a business, who's going to be able to make payroll or access your business accounts? Healthcare proxy, make healthcare decisions. A living will, that gives what you intend to have in terms of medical care. You don't want any extraordinary life-preserving treatment. It's actually technically not recognized in Massachusetts, but it still shows your intent as to what you wanted. It's recognized in other states, but at least in Massachusetts, it's not per se recognized with legal authority. In Massachusetts, we look to the healthcare proxy, the person you name to make your healthcare decision. Living will only comes into effect when there's a dispute among your family members, that mom wanted this to happen, but another child says something else. Sometimes they'll look to the living will to help out, but typically they look to the healthcare proxy to make their decisions. And finally, a HIPAA authorization. If you give someone the authority as your healthcare proxy to step into your shoes to make your life or death decisions, you want to be able to talk to the doctor in terms of your medical care. Or maybe you name one child as a healthcare proxy, but you give all the children the ability to talk to your doctor to see what's going on, to help assist the person you named as healthcare proxy. So again, the same story. So these are the other documents over and above the wills and the trusts you should think about. These other documents you should really consider. And with that, I thank you for everyone. I thank everyone. Certainly, if you have any questions, please let me know.
All right, Phil. Well, we have a couple of questions from our chat box. Somebody wants to know, is there a deduction on real property when considering Mass Health?
Well, there's a couple of different ways of looking at it. So, if you're a spouse, you're paying for a spouse, the intent is always to permit the surviving spouse to live at the same level. So you can transfer the property. Certainly there is a deduction for that. But again, remember, it all depends how you set up your estate plan. If the property was put into a irrevocable trust, you made it through the 5 years. Remember, it's in that steel box, it's protected. So again, it all depends on your situation.
Okay. And can you place only 1 million part of estate into trust to avoid mass estate tax?
So what we do is we typically say up to the mass estate tax threshold. Right now, it's currently at $1 million. So you want to carve out that first million because estate taxes aren't implicated. Again, if we're talking about a couple, they're not implicated until you have the second to die, because that's when the estate tax will be due. So what we do is we do up to the maximum amount for the first to die. All right, because suppose you have that $3 million estate that we talked about earlier. So we want to, half would be attributed to the husband, the other half would be to the wife. But we want to carve out up to the maximum to attribute to the first to die. So it's more looking at the total estate on the second to die. So the 1 million's been carved out. We now have a total estate, size of 2 million on the second to die. Again, if you go over the limit, there's no benefit. So we want to, again, depending on the language that we include in the trust, we just want to carve out the maximum. Again, tax policy changes every year. So we don't know what the future is going to hold. So we want to make it flexible to make sure we maximize that sort of deduction is the way to look at it. So just going back to that example, we carve out $1 million, which is currently. So the new estate tax size, total estate size is 2 million instead of 3 million. You can see the effect it would have on the estate tax obligation.
All right. Another question is, aside from estate tax, if all assets are joint or beneficiary, is probate avoided?
Yes, if all your assets are jointly held, or there's a named beneficiary like retirement accounts or life insurance, all your assets, then there's no need for probate. So that is certainly one strategy. Just make sure if you create a trust, fund the trust, retitle the asset, put it in the trust, or all your accounts have named beneficiary. I can't tell you how many times where we think we found all the assets, but we have a long forgotten savings account that has several $1,000s in it, that is just in the decedent's name alone. That would have to be probated, unfortunately. So if you're going to go that route to avoid probate, certainly jointly held beneficiaries, that those assets, and also real estate, if it's jointly, if it's if it's a husband and wife, tenants by the entirety, it would go to the by operational law, would go to the joint title holder. So yes, that is a well-recognized strategy to avoid probate.
Great. And what is the average cost to set up a trust?
It all depends. I mean, it's really, your situation. We're talking revocable, irrevocable, a living trust, as your sub-trust. I mean, it really depends. It could be anywhere between 4,500 to, 10, 15,000. It all depends how complex your situation is and how many trusts, how many moving parts. So it really depends. But again, if you're looking at the costs of the administration of your estate, a trust absolutely is going to be more upfront than having just a basic simple will. But if you include the probate costs, remember, a will has to be probated. If you include a total cost of estate administration through your, through the probate courts, much cheaper option.
How much does a probate typically cost then?
So as a rough rule of thumb, a lot of it depends on the assets. So if you only have an asset or two, it makes it much easier. And also if you have family harmony, people get along, your heirs aren't going to object to this and that, much cheaper. Maybe if you look at the total estate size, I often quote, $5,000 to $7,000. But when you have objections, people needlessly filing stuff and using the courts to solve some other purpose, it can go up. I've had probate case approach 6 figures. So on average, I say around 5% of the total estate value, just give you rough numbers.
Mm-hmm.
So just to give you a sense of what probate costs. There's also a lot of filing fees with a court. Just to file a petition in Massachusetts, just a first step among many, $409 filing fee in Massachusetts. There's a lot of other subsequent filing fees. You have to publish to the newspapers the legal notices, notify all claimants of the estate. They have to be sent notification of the probate. So a lot of steps, a lot of interactions, a lot of places for people to kind of what I call muck up the water, so to speak.
I think that does it for us for today. Thank you so much, Phil, for all that information.
All right. Thank you for attending, everyone. I've enjoyed it.
And thank you, everybody. And we will see you all in the next one.